DWI, also known as DUI, essentially it's the same thing, is one of the most commonly charged offenses in the state of Minnesota. It's also one of the most complex and technical areas of the law. It's important that you have an attorney that's very experienced in handling specifically DWIs, not just necessarily criminal defense work, but DWI, because that's a whole other area of law. DWI in the state of Minnesota can be charged when somebody is operating a motor vehicle while impaired either by alcohol or drugs or even some substance that may not be illegal per se, like paint thinner or keyboard cleaner, anything that can impair your ability to drive. You can be charged with a DWI while operating a motor vehicle, operating a boat, operating a snowmobile, an ATV, a golf cart, essentially anything that is motorized. In Minnesota, there are 4 levels of DWI. There's a first degree, a second degree, a third degree, and a fourth degree. Your average first offense DWI, where you test less than twice the legal limit, with the legal limit being 0.08, is going to be a misdemeanor fourth degree DWI. It has no aggravating factors. Second degree and third degree DWIs are gross misdemeanor offenses. And what elevates that charge from a simple fourth degree misdemeanor to a higher level is an aggravating factor. Aggravating factors in Minnesota are prior DWIs within the last 10 years. Now that includes a criminal conviction for a DWI as well as an alcohol-related loss of license. It's known as a prior qualified incident. In a lot of cases, people think that because they got a prior DWI dismissed and pled to a careless driving, that won't count against them. That's actually not true if there was a license revocation that was still associated with that case. At any rate, one aggravating factor would be a prior qualified incident within the last 10 years. Another aggravating factor is testing 0.16 or more, which would be twice the legal limit. And another aggravating factor would be if you had a minor under the age of 16 in the vehicle with you. What determines the level of offense or the degree is the number of aggravating factors that you have. Again, if you have no aggravating factors, it's a fourth degree misdemeanor DWI. If you have one aggravating factor, it becomes a third degree gross misdemeanor DWI. If you have 2 aggravating factors, it becomes a second degree gross misdemeanor DWI. Lastly, Minnesota has a felony DWI law. A felony DWI is charged if it's someone's 4th or more offense within a 10-year period. No other aggravating factors matter here. The only way to get to a first-degree felony DWI is to have 3 prior qualified incidents, making this the 4th, or if you've ever been convicted in your entire lifetime, whether it was 11 years ago, 4 years ago, or 50 years ago, if you've ever been convicted of a felony DWI or criminal vehicular operation, that new offense becomes a felony DWI. Misdemeanors are maximum punishable by 90 days in jail and a $1,000 fine. Gross misdemeanors are punishable by a maximum year in jail and a $3,000 fine. And the penalties for felonies can vary depending, again, on the history, how many aggravating factors you have, and your overall record. For more information on DWI offenses, call us for a free consultation at 651-341-5367 or visit our website at www.DefendingMN.com.